Okay, so this is constitutional structure, the first take, and I'm going to be writing questions down as we go and hopefully getting them clarified and then doing this again. So, constitutional structure. The federal versus the state. State courts have the ability to hear almost any case, the ability to grant higher protection to their citizens than the federal government, but not lower. So they can add to the protections by law, but they cannot go lower than that. Federal courts have jurisdiction over federal questions, which are constitutional laws or treaties. They can also hear diversity of citizens, which are citizens of different states, and diversity of aliens and citizens, so citizens versus people from other countries. The authority to set the minimum level of protection for federal rights. The 11th Amendment talks about the diversity of jurisdiction. So, here it is. A private entity cannot sue a state in federal court. Private entity cannot sue a state in federal court. Sovereign immunity says government cannot be sued without its consent, but only with regard to diversity of jurisdiction. Okay? So here's the rule. Anytime a state is sued by private citizens or groups, it's a sovereign immunity issue. So this is all 50 states. A state is a state. Oh, state-to-state litigation is not excluded. And the feds can sue the state. So this only applies to private entities, and they cannot sue a state. And a private entity is a business or a person. Second part of the rule. A state employee in their official capacity can also not be sued for doing their job. So, a state employee, official capacity, cannot be sued if they're doing their job. But the exception is called the stripping doctrine. And if it's a named official, in an exam, we're looking for a specific person, good. And then, they're being sued for injunction to enjoin or for declaratory. So they're trying to change the situation. They cannot sue for damages. But official position, one named person suing to do something. And the third part is you have to allege the official is violating some constitutional right or federal law. So something they're doing violates a constitution or federal right. And it can only be a federal right. If it's a state issue, doesn't work. So, once again, state official, state named official, so it's a specific person. You're suing to enjoin, and you're alleging that the official is violating some constitutional or federal right. Last bit of this is a city, county, subdivision is not a state. So we are talking about the named 50 states, and that's it. We can ask about territories. Anyway, another exception is called abrogation. Abrogation means that they're going to allow you to sue the state for explicitly stated reasons. So, and this is given by Congress. So Congress can clearly say they are intending to allow abrogation for specific liability. And so if they do that, then a person may sue for, a private entity may sue, and they also may sue for damages. This is only for due process or equal protection issues. State courts have their own parameters about suing that we're not going to get into because it's the Constitution. So, separation of powers, federal government. The executive branch. So the executive branch gets their power from the Constitution, from history, and or from Congress. So there are 3 levels of how these history, Congress, and the Constitution work together. And that number 1 is the strongest power, and that is Congress authorizes the president to do something. So that means that the president is getting his power or her from Constitution, Congress, and history. So that's the strongest. This could be something like his veto power, but when Clinton tried to use his line item veto, they said, no. Like, you get to say no or yes to this whole thing, but you can't go piece by piece. The Constitution doesn't allow that. So no, Mr. President, you cannot do that. So power to veto would be that. Congress, okay, the second one is kind of a twilight zone. It can go either way. There's lots of views on different issues. So then the second level, the twilight zone, is Congress hasn't authorized, but they haven't prevented either. So really what we're relying on is the Constitution and history to allow a president to act. The third is the lowest restraint, and it's when Congress says the president cannot do something. The president can only get around this if he can show that that Congress is in violation of what the Constitution gives him the power to do. History doesn't matter. If historically a president has always been able to do that, doesn't matter. Congress has the ability to say, we're not going to do that anymore. But if the Constitution says he's allowed to, then he's allowed to. So some of the power from the cases we looked at, which I didn't feel like fit very well, but okay. Maybe that's a good question to ask. So I need to stop saying that's never been my thing. Absent national security, the president cannot seize industries. That's a pretty good one to me. Congress was challenged. Oh, so the independent counsel law, Congress challenged and asked, can Article 3 judges be assigned non-judicial duties? And the answer to that question was yes. And they said, as long as they do not usurp authority of the other 2 branches or threaten the integrity of the judicial branch. So that's that. The president has appointment power. And this power is shaped and given by the Constitution. So he has the power to appoint do principal appointments, and these are like the president's cabinet. They serve at the pleasure of the president's. Maybe that's where that term comes from. But these are appointed by the president and then confirmed by the Senate or Congress. I put the Senate. I'll ask which, if it's both. It could be, I think it's both. I'm pretty sure it's both because we've dealt with that process here in the world. So the principal appointments are appointed by the president, confirmed by Senate. The other are called inferior appointments, and Congress decides how these are appointed. Inferior can be decided by a group that has limited. Oh, an inferior can be a group, but it's limited. So sometimes it's limited scope or purpose or duration. So if they have a task, then once that task is completed, they're done. They don't necessarily have, anyway. So there's 3 different ways that these inferior appointments can happen. And 1 is the same as above, the president appoints and Congress confirms. 2 is Congress can allow appointment by the head of the department. Usually the departments are the principals, so it's giving them a little power. And the 3rd is judicial officials can appoint those positions. And Congress decides which positions get which way. The president also has removal power. This power is not so clear by the Constitution. So a president has absolute and total discretion to remove an employee who the president has to trust without reservation. So these are generally like his main cabinet people, all principal officers, but can include inferior officers like a speechwriter. Some positions have to be somewhat removed by design. If they're always afraid of getting fired, that doesn't work if they have to do regulation. So in these positions, the president doesn't have unilateral ability to fire. These people, Congress can remove, and the standard is they need good cause, and good cause is not well defined. So once good cause is used to protect, it's often litigated. Congress can require good cause, but it cannot require permission. So it can't say the president can fire on the permission of Congress. That's not a thing. But it can require that there be good cause for these removed positions. The president also has immunities. This is executive privilege, which means that certain conversations are protected and cannot be listened to. These are like key advisors. This gives them the ability to talk and say what they need to without fear. It gives them freedom to speak freely. But in some cases, like in Nixon, this does not apply to a criminal case for a judge. And so a judge in a criminal case can compel it, but if it's if national security is at stake, the president can say, who makes that decision? Just the president? I don't know. Does Congress have to say yes? We'll ask those questions. Those are great questions. Maybe the court does. We're going to ask. Does the president get to just say, no, it's about national security? Okay. The president has another immunity. The president has absolute immunity for civil suits related to official duties, but no immunity for unofficial. This is like Clinton v. Paula Jones, where we don't need to get into the case. But basically the suit was brought while he was president. He wanted to get it pushed. Well, one, he said, I have full immunity from civil lawsuits. And they said, no, no, you don't get a pass from things you've done before. This wasn't in your official capacity, so the civil suit can go forward. And then he wanted it to push off because he was too busy. And Rehnquist basically said, you're not too busy to play golf, so you're not too busy to answer a lawsuit, which I think is brilliant. Legislative branch. They cannot change original jurisdiction because that is given by the Constitution to the courts. Has somewhat unlimited power to change appellate jurisdiction. They cannot dictate how the Constitution must be interpreted, and they cannot take away the judiciary's right to protect the Constitution. The judicial branch, Marbury v. Madison, gave the Supreme Court power to judicially review the constitutionality of legislative and executive administrative actions, striking down legislation inconsistent with the Constitution. And it gave the power to interpret what the Constitution means. Marbury v. Madison lost on its writ of mandamus because it didn't have original jurisdiction there. Jurisdiction. Article 3, Section 2, Part 1 expands the Supreme Court original jurisdiction only to representatives of foreign governments and cases where the state is a party. Those are the only two cases that the Supreme Court has jurisdiction over. Representative of foreign governments, cases where the state is a party. Look what happens when I do this at night. Congress has no right to expand this jurisdiction. Article 3, Section 2, Part 2, I don't need to know these numbers. Congress has the broad, if not unlimited, power to define the Supreme Court's appellate jurisdiction and that of lower federal courts. This does not give Congress the right to dictate how the Constitution shall be interpreted. That is the judiciary's job. Congress cannot take away the Supreme Court right to protect the Constitution. So in its defining the appellate jurisdiction and lower courts, it can't say, well, you can't hear free speech issues because that's a constitutional issue. They can't take that away. So, Supremacy Clause, the federal law is supreme. Federal law is always supreme over inconsistent state law. Professor McGoldrick said that 5 trillion times during this semester. Perfect. You better know it. Judiciary Act of 1789 created lower federal courts, created jurisdiction in state courts where the U.S. was the plaintiff. Supreme Court can review any state decision over federal questions, but not state questions. States get to be the captain of their own ships. The Supreme Court can decide cases still before a court at the state level. So if it does go up, but some courts have gotten in some trouble for this because if there's a federal question that a state, we're going to keep going, but sometimes the feds, if you jump, say that's a state question. Whereas if you let it litigate the whole way through, they may have come up with a better federal question that independent and adequate state grounds, and then you could have kept going. So that's maybe, anyway, strategy later. Brilliant lawyers we're going to be. Doctrine of adequate and independent state grounds. Oh, we're there right now. Yay! Okay, broken down. Adequate. Adequate means a procedure. So procedure advances a state concern. It's got to be an adequate state concern. It cannot be, oh, instead of a male or female pronoun, you crossed it out and put your own or put person, and then you signed your name, and now we say the form is invalid because you did that. No, that's not adequate. But it could be the paper size of the file. Anyway, and basically, does this procedure advance a legitimate state interest? If it does, then it's good. If it doesn't, not happening. Independent. It needs to be fully reasoned on state grounds. So state substantive rules are the merits of the case, and if the state law fully resolves, then no standing for a federal review. But, so, main rule, Supreme Court can decide federal questions. Exception, doctrine of adequate and independent state grounds. Exception to the exception. So, if a state issue fully answers a question, then it can't be federally reviewed. But if the state grounds involve the state constitution and the state constitution mirrors the U.S. Constitution, then the Supreme Court can hear the case because it is not independent. It is based on the national one, and the state, if using a mirror image, cannot say it means something different. This rule was to keep the Supreme Court from giving only advisory opinions. The Supreme Court has no authority to decide state law, only federal questions. If a case has a mixed federal and state issue and cannot be decided on state issues, then the federal courts have no authority to review. If the state has mixed federal and state issues and it can be decided on a state issue, then the federal courts have no authority to review. Sorry, I need a tissue. The doctrine of justiciability. which Professor McGoldrick said was a slippery worm. A case must be justiciable before getting ruling on the merits. So this is based on cases and controversies. There has to be a case and a controversy, and it has to be real. It can't be hypothetical. And something says political questions. I'm not sure why it's right there because there's nothing else about it, but we'll maybe talk about it later. So justiciability is about standing, ripeness, and mootness. And we're going to talk about those three things. But first, we're going to talk about standing. So the elements for standing are the plaintiff must have an injury in fact. It could be a legal injury. It could be a personal stake. It could be damage. Discrimination is one of these. Anyway, injury must be fairly traceable to the challenged conduct. Injury is caused by what is being challenged. And it must be capable of a judicial resolution. Okay, third party. Rule. A party can only litigate their own constitutional issues. The exception for this is a party has to be injured in some way. And they have to have some connection with party. When a state can sue, when can a state sue on behalf of its citizens? The rule is when it has close relation to what has begun. I don't know why this one is right here. But what we're talking about in this jumbled mess that I just said is party has to be injured in some way in order to sue. That is true. So we're talking about some groups being able to litigate, and one of those is the state. And the rule with the state is a state cannot sue on behalf of its citizens if it's suing the federal government. We're going to ask about that. But if it's like the state suing the EPA for not doing something, then it's allowed, because basically what the state is saying is like, you, federal government, are over us and protecting us, and this isn't being protected. And so it's asserting the authority of the feds, but they are not allowed to sue in more of a like patronizing way, because the federal is supreme. An association can only sue for issues related to its membership. So it can usually be found in the name. But they can only sue if their members have standing. So if they're just suing because it's a topic that the association works for, not going to work. But if the members have injury, then they can sue for their members. But they can only sue to enjoin or injunct. They cannot sue for damages. A third party has to have a close relationship. So like parents a lot of times sue on behalf of their children. And that's especially true if a party has difficulty protecting their own rights, like children, the courts usually will allow. Taxpayers may litigate any tax, but they may not litigate how the tax is spent, except if it challenges spending power, and it violates the Establishment Clause, which is the separation of church and state. And this is only congressional spending. So the exception to the may not litigate how money is spent is it needs to challenge spending power that relates to the separation of church and state or the Establishment Clause, which are the same thing, and it's only congressional spending. It's not executive spending, it's not property, it's not tax breaks. Congressional spending about the Establishment Clause, separation of church and state. That's it. Congress can create rules that didn't exist, like the American Disabilities Act, but Congress cannot give citizens standing outside cases and controversies. So the sponsor of a state bill and the state won't enforce it, the federal government, the state gets to do what it wants. The Endangered Species Act, it said that we weren't going to protect animals outside of the country anymore. These researchers said yes, but I was going to go and study them, but there was no plan, there was no purpose. This hypothetical going to study them wasn't a case in controversy, and Congress can't just say it is. Prudential rules are rules of self-restraint of the court. So the court can put rules on itself. So that's standing. Mootness is, mootness. Federal courts cannot hear a moot case. Mootness is like filing too late. So you're in the cases and controversies, and the controversy is over. And therefore the court says, well, you have nothing to sue for, so we're done. This could be because something's changed in the facts, or there's been a change in the law that makes it moot. There's some exceptions, though. Voluntary cessation. Just because an activity has stopped doesn't mean they cannot start up again voluntarily as well. So this is like the midterm question where the chiropractic school stopped its ban on transgender people, but they voluntarily ceased the ban. So they could also voluntarily put it back on. So that means it's not moot. Residual harm. If there's a lingering harm, so if they're litigating like a felon, and he's no longer in prison, but he carries that name, and there's like residual issues with being a felon. Capable of repetition but evading review. This is like any abortion case because typically it's going to take longer than 9 months, and they're going to find another way to do the abortion, and they say, no, this is going to happen. So over and over and over. So it's capable of repetition, and it evades review because of the time frame we're talking about. Courts are inconsistent with how they do this based on class of similarity situated people. Class representative. Certified class action is represented by So if there's a class action, there are people designated as the representatives, and when they're designated as a representative, they cannot lose their standing or mootness. So I don't have a hypo for that. But if a representative is chosen, they cannot lose their moot. They can't be waived off as moot. Controversy must be current through all legal proceedings, not just when filed. So this is the rule. It has to be current through all legal proceedings, not only when filed. Sorry. Ripeness, concreteness, which is concreteness, and how mootness was filed too late, ripeness is filed too soon. Standing looks at the right injury. Ripeness looks at sufficiently real threat. So, is the threat to injury a real threat and not just an abstract hypo? Challenge to laws on their face. Sometimes there just are not enough facts to see if a threat is real. Ripeness is looking at bringing it into focus. Usually ripe are threatened injuries and threats of persecution. The Susan B. Anthony list is the hypo for this one. Now we have political questions. I'm not sure why it's right here, but okay. This is a separation of powers issue. This separation of powers issue, they can be expressed, demonstrate textual commitment from the Constitution, or implicit. Constitution does not say branch has power, and it's not judicially discoverable. So one thing to know about ripeness is it's like the student the law school student, and they let him in, and it was before the Supreme Court, and they said, so if he loses, are you going to kick him out of school? And they said no. They said, well, not right. So I think political questions are actually, they should be the next portion of this. Political question is a separation of powers issue. Separation of powers, this can be the Constitution. Sometimes there is demonstrable textual commitment on the separation of powers, and sometimes it's implicit. The Constitution does not say branch has the power, and it's not judicially discoverable. Tasks committed exclusively by the Constitution to another branch are political questions and not justiciable. That's why they're here. That's why it's here. Tasks committed exclusively by the Constitution to another branch are political questions and not justiciable. These can be expressed in the textual, demonstrated textual commitment to the Constitution, or they can be implied textual commitments. So looking past cases, are their standards typically applied? These are only, political questions are considered to be able to be remedied through the political process, which is voting. The executive has exclusive right to pardon or veto and recognize countries. This was a passport issue. Legislature, Congress, power, they have the power to indict, power to seal constitutional amendments. Senate has the power to impeach. Enumerated powers. I need to get water, so stay right there. Enumerated powers are the things that Congress can make federal laws on. Congress cannot regulate outside of the enumerated powers unless the Constitution specifically says it can. Because we always have that caveat. It's so nice. Not really, but whatever. Okay, enumerated powers. Necessary and proper is not an enumerated power. Necessary and proper means an appropriate relationship to the end. So, if something's trying to be regulated it has to be related to an enumerated power and to the means being necessary and proper to get to that end. Congress may pass laws necessary and proper to carry out an enumerated power. That was so nice. I should have just read it instead of tried to on the fly make something up. Anyway, necessary and proper could be substituted as direct and simple, but it doesn't always have to be the most direct or most simple. Anyway, federal laws must be pursuant to an enumerated power. States do not have this hurdle. States can do what they want. Examples. Civil commitments after incarceration originated from the enumerated power of the original case committed for. So if you are put in jail and they think you're crazy and they don't want to let you out, they can civilly commit you and they can say it's based on your original crime. It can also be raised and support an army is on the banking power. The post office is allowed exclusive power to regulate Washington, D.C. There is a war power. There's a power to tax. There's to provide for the general defense and welfare and to regulate commerce. The big three enumerated powers, are the commerce power. Congress has the enumerated power to regulate commerce among states, nations, and Indian tribes. Unlimited authority. What is commerce? It's buying, selling, it's all forms of commercial intercourse, and it's navigation. What does regulate mean? Total, complete, unlimited power, and plenary. The other two are spending power and taxing power are the big ones. No one can expand from this list. So people always talk about term limits, but the Constitution says that the limits are age, citizenship, residency is the only thing required for Congress. And so if people say, well, we want term limits, well, that is not age, citizenship, and residency. It's just not. And you can't add to it. So legislative lines can be drawn by appointed. So like in gerrymandering, it says the state has to do it, but the state can appoint a neutral third party. Congress has implied power to select means to accomplish enumerated power. This is literally necessary and proper. How close does it need to come? Not close. Congress can make a bank. States cannot tax. States cannot tax the federal bank. Necessary and proper does not mean absolutely necessary. All right, so we're going to talk about the Commerce Clause, which is a beast. So okay, so dormant is where Congress has not acted, which is also a lot of places. So here's the starting place. The court's presumption is, I don't know why I put this here. Anyway, so right now we're talking about state issues, which is, anyway. Court's presumption is if the field is in a if the field is traditionally within the power of the state, then the presumption is for the state unless clear evidence is presented for preemption. Preemption is federal government preempts state. But if the area is, so that's like a domestic area. If the area is not traditionally a state issue, then the presumption is not going to be for the state because federal trumps state. Where federal is there, it preempts state. This can be expressed. The federal law states that's easier to win. But if it is not expressed, Congress does not expressly say, but manifests an intent to do so. So there's field preemption, and that controls from Congress are so pervasive that it leaves no other room for regulation. Intent is pretty unmistakable in this area. If field is generally left to the states, the court will likely rule thusly. Oh, I just said that. Anyway, okay. If there is a broad federal regulation of a national matter, the state will likely rule with the Fed. I think I actually may have written this twice, so we may be hearing this again. So the federal regulation for nuclear power plant for safety reasons, California puts restriction for economic purposes, but it does not conflict with federal regulations. It's probably going to be fine. Licensing does not automatically mean preemption. So that's field preemption. The other area is conflicts preemption. And there needs to be, if there is direct physical conflict, the Fed is supreme. But where state regulation purpose is inconsistent with Fed regulation. So conflicts is a lot of times you can't do both. Easy. Federal always preempts. But if it's about look for what the federal regulation was for. Was it for uniformity, or was it to give a minimum standard of care, which is not the right word for it, but I'm tired and I don't have it written down. So, was it for uniformity of the market, or was it for a minimum standard? If it was for uniformity, even if it's non-conflicting, the state regulations will be struck down. But if Congress was simply passing a minimum, tighter state restrictions will be allowed. When commerce crosses state lines, it is commerce power. This is called in commerce. Individual states are incompetent to handle matters dealing with other states. That's the thought. No limits on how Congress can regulate this commerce power. I'm sorry. Examples: the Lambert Act, kidnap and move person across state lines. Can't do it. Interstate commerce. Federal crime, FBI can cross state lines. These are all examples of things that are in commerce. Aviation, railroads, guns, radio, TV, internet, all cross state lines. Blackbird Creek, cross state lines. Lottery tickets, impure food and drugs, women for immoral reasons. Those women. If something crosses state lines, it does not have to be commercial. It does affect commerce. If it crosses state lines, it's commerce. Congress has the power. So if it crosses state lines, it is commerce, and Congress has the power to regulate. And there's channels and there's instrumentality. Channels are like bridges, roads, things traveling, and the misuse thereof. Instrumentality of interstate commerce is anything carrying things across state lines. It's the things in interstate commerce. I'm probably going to ask for a little bit better definition, or at least a picture for my head. Ooh, sorry, bed. Basically, anything crossing state lines is instrumentality, or is one of those things. Anyway, if it has substantial impact on anything crossing state lines, it's commerce power. The Fed can regulate local activity to protect interstate commerce. So necessary and proper, it has to be appropriate. If it's necessary and proper, it's appropriate. It means regulation of local activities must So when they're regulating, we look at necessary and proper, appropriate, and we're looking at appropriate means of regulation of local activities must bear a substantial effect. So if they're trying to regulate a local activity, what they're going to do is they're going to look at for a substantial relationship. And a substantial relationship test is looking at the practical factual evaluation of does something substantially affect interstate commerce. But we have another test. Maybe you say no. Then you're going to go to the substantial relationship, practical factual evaluation. Rational basis test is conceivable. So, could Congress conceive that there could be a substantial effect? The burden of proof is on the other side to show that Congress doesn't. Assumption is Congress would conceive that it would have a substantial effect. So the other party has to show no, it doesn't. They wouldn't conceive it. We can look at class or aggregate impact shows substantial impact. Race established preeminence of this test. Which I don't really need to know that. Examples: racial discrimination, homegrown wheat, but not backyard carrots. Goods made for less than minimum wage. They were sold across state lines, so Congress does have the power to regulate. Gender and race-based violence is on discrimination by the state, not individuals. Overturned tests. Guys, we've got so much more. Stream of commerce, indirect, direct, dual federalism. We're not using those tests anymore. Here's the test for the whole thing. If a question is, can Congress regulate this local activity? You answer yes, then Congress would rationally believe that they could, and we're done. But if the answer is no, I didn't answer my question. Okay, can Congress regulate this local activity? You then apply the substantial impact test. You look at class impact, you look at aggregate impact, and then you say, does it impact? Yes, then Congress can rationally believe it does. But if you say, no, it doesn't, we don't see it impacting, then you say, okay, but could a court believe Congress could rationally believe that there would be an impact? And the burden is on the plaintiff to show no. There wouldn't, it couldn't, anyway. But a criminal impact is never a viable claim because they don't say that criminality is reasonably foreseeable. So an exam hypo. Challenges are about individual effects of power being applied to them. On an exam, law applied to 5 people. 1 crosses state lines, so it has direct impact. 1 is strictly local, so is there substantial impact? Could Congress rationally believe there was impact? 1 is charged. One is charged, and 1 is in the same situation. So now we talk about ripeness because it's a viable threat. When an illegal product is solely in one state, it makes it too hard to differentiate it from products crossing state lines, so it does affect commerce. Loan sharking, marijuana, homegrown marijuana. Anyway, Congress power gives uniformity to states in regards to interstate commerce. Federal power prevents states from regulating interstate commerce differently. The Dormant Commerce Clause. feel like I spent the most time, or just the closest time on this. So, does the mere fact that the Constitution gives Congress the power to regulate interstate commerce prevent a state from taking a particular action which affects interstate commerce? Approach. Is the state affecting interstate commerce? We're going to look for discrimination. If it's clear, then it's per se invalid. If there's a purported reason / difference, we're treating out-of-state things differently because they are different. Then we look if the law is even-handed, and we balance the burden to interstate commerce with the intended state interest. And then we look, is there a reasonable alternative that would not discriminate? And we look, is there a direct or indirect, which is big, or indirect, which is an inadvertent burden? We also say, okay, does this activity qualify the state as a market participant? Are they buying, selling, or employing anything? And then we say, is it acting as a participant or a regulator? Is the participant trying to control the downstream market? So if they are a market participant and they're selling things, are they saying, and it must be, we're giving you this shrimp, but it must be processed here as well? Doesn't fly. They can't control downstream. Does it deal with the privileges and immunity right, which we'll talk about in a minute? If it talks about citizens, then we need to talk privileges and immunity that touch the Dormant Commerce Clause. Limit on state power. The mere existence of the federal commerce power restricts the state from discriminating against unduly burdening interstate commerce. Constitutional limits. Express limits. These actions are set forth in the Constitution that limit state power, such as export duty. States cannot impose a duty on things from other states. Implied limits. Where the Constitution gives the feds authority, it does not automatically mean that the states do not have the power to regulate. Here there is no general rule, and the Supreme Court decides areas on the basis by case by case. Court limits. Court's approach always weighs the state interest in regulating local affairs against the national interest in the uniformity or an integrated national economy. So like railroad widths, Congress has full power. Ports need more diversity, allowing for local regulation. States are allowed to regulate. But Congress has the ultimate say. Limitation on state commerce-related conduct imposed by the court may always be reversed by Congress. Three-part test. A state regulation which affects interstate commerce must satisfy each of the following three requirements in order to avoid violating the Dormant Commerce Clause. 1. Regulation must pursue a legitimate state end. This can be health, safety, and welfare. The court likes this, but requires substantial evidence if there's evidence that it is for an economic reason. The court doesn't like it when states are promoting the economic interest of its own residents. If it materially affects interstate commerce, the court will not see a state's economic interest as a legitimate state end. Regulation must be rationally related to the legitimate state end. It means to an end it is all that's required and doesn't have to be good or best. So is it a legitimate state end? Is it rationally related to the legitimate state end? The court will not do its own fact-finding, but will give deference to the state's fact-finding. So, blow polls. The first one that litigated it just said it makes it more complicated, and they lost. And then a train said, hey, stopping at all of these blow polls makes a 3-hour trip take 10 hours. And they said, oh, okay, well, that's unreasonable. So the regulatory burden imposed by the state on interstate commerce and any discrimination against interstate commerce must be outweighed by the state's interest in enforcing the regulation. So this is the balancing test skewed towards finding constitutionality, but can be overcome by clear evidence showing that national interest in uniformity outweighs the state benefit. Less restrictive alternatives. The court balances objectives. State is pursuing when necessary of the means and less burdensome alternatives. That doesn't make any sense. Court balances objectives the state is pursuing with the necessity of the means and less burdensome alternatives. Dean's milk case. State objective, clean milk. Necessity of means, only allowing from in-state regulated inspected factories made sure milk was clean. Less burdensome alternative. At milk producers' expense, the inspectors could have gone out of state to inspect those plants and not burdened interstate commerce. Local versus national subject matter. If subject matter is local, it is more likely to be found to outweigh national interest. Intentional discrimination. Courts do not like discrimination against out-of-staters. If a state is promoting its residents' interests, will not be seen as legitimate state objectives, so the regulation will almost always be found to violate the Commerce Clause. When locals and interstate are equally barred, state regulation is generally permissible, though it affects interstate commerce. We're going to find a lot of situations where that's not true. Considered the police power, regulations that upheld health and safety measures. Exception. If the state acts as a market participant, it may favor local over out-of-state interests. The Dormant Commerce Clause analysis does not apply. So, if the state is a purchaser or a subsidizer, as opposed to a regulative function, as below, running a proprietary enterprise or subsidizing private business. So, if they are a market participant, they may favor themselves. This could be the crushing car business or they're running a cement factory. They cannot impose limits on buyers to control the market downstream. We already talked about that. Subsidies are allowed. Regulation on transportation. Instrumentalities of interstate commerce, generally roads and highways. When state regulate, it's usually done in the name of safety. Rationally related means and safety objective and burden balancing. Benefit of state to burden of commerce are normally looked at as legitimate state interest is generally given. Absence of discrimination. If the intent or effect creates burdens on interstate and intrastate, the court likely sees this as something the political process will protect against abuse. But Dean milk case, only milk within 5 miles of the city could be sold. Found discrimination, and it didn't matter. It was both in state and out. If it's based on economics, the court will likely strike it down. Balancing test. Even when transportation regulation pursues a legitimate state end, public safety, in a rational manner, a balancing test is often given, weighing benefit of regulation to state against burden of interstate commerce. If safety is marginal or speculative, it will be struck down. Otherwise, not. Look for discrimination or protectionism. Courts would rather look for discrimination instead of balancing and will strike down. If something is different, out of state, cattle that are diseased, minnows that are diseased, then a state can treat it differently. If it is not different, then it's discrimination and per se invalid. If the state purports an interest, then the court may balance it. Cumulative, actual, or contradictory burden. If multiple states have differing rules, it may create a cumulative effect that in concert violates the Dormant Commerce Clause. Examples: mudguards. 45 state have regulations. Arkansas said it must be straight, but Illinois said contoured. Illinois was struck down as both could not control. Train length. The state with the shortest length would then control the country's train length, which is an undue burden on interstate commerce. State barriers for incoming trade. Test depends on state interests being served. Protection of economy. Where state is protecting in-state producers from competing out-of-state commodities to strengthen the local economy, the court will generally strike it down, usually without a test as illegitimate. It's the mere fact of discrimination, not the magnitude, that counts. This is the minimum price set for milk producers in New York, and out-of-state milk was taxed to meet this minimum, struck down as this guards New York against economic rivalries from out-of-state. Here, only out-of-staters were burdened. Health and safety. Court will use a balancing test, but they will look for unintended discrimination, and if there's less burdensome or discriminatory alternatives. Intentional discrimination. Washington apple case. North Carolina wanted the U.S. apple grade or none at all, putting the burden on Washington to change their packaging. It could be shown that it wasn't for welfare of consumers, as consumers wouldn't see the packaging, and the state allowed apples with no grade. Discrimination by city against out-of-towners for economics are generally not allowed. I said that a lot. Facially neutral statutes. Maryland refiner, producer of oil. Their policy discriminated against refiner producers, but 100% of their gas was still coming through the interstate commerce, so it was not substantially affecting the market. The bigger fear of the refiner producer was not Maryland, but the other states would adopt the same concept. State barriers to outgoing trade. Local versus national. If concern is local, the effect on interstate commerce is incidental and not discriminatory. It will most likely be upheld. But discrimination is struck down. New York can't deny a milk license to Massachusetts just to make sure they have what they need. Michigan can't refuse to sell cars until Michigan dealers need to be met. Ohio can't retaliate for not selling tires to Michigan. Embargo on national resources. Court uses strict scrutiny. Only upheld if less discriminatory alternatives are available. Minnows violate Commerce Clause because alternatives could have been used. Local processing requirements. Natural resources also must be processed in the state. Arizona cantaloupes. Per se invalid. No, none of that's true. You can't regulate downstream. Well, that's not even downstream. That is local processing requirements. Natural resources also must be processed in the state. No, they don't. Garbage. A local town could not restrict it to a local private processor, even though it was discriminatory to both in-state and out-of-state facilities. A public processor is not, so that's private, but a public processor would be considered a market participant. Environmental regulations, strict scrutiny, and struck down only if no less discriminatory alternatives. A state may not improve its environment at the expense of its neighbor. Landfill waste is not allowed to be discriminated against. A tax is allowed if in and out of state is taxed the same. Quarantine laws, which rely on when the infected thing crosses state lines, are allowed to be upheld. Burden yet not discriminating may be allowed. Plastic containers are not allowed, but plywood, cardboard are, when Minnesota was the main manufacturer of cardboard, but not plastic. Sounds fishy to me. How Congress can block states from legislating in particular areas. Preemption. Valid Fed always preempts inconsistent state law. Express Congress says it. Implied field at preemption. Congress wants to regulate everything in the whole field. Uniformity. Conflict preemption, where it's impossible to follow both state and local, federal. We already said that 3 times now, I think. Privileges and immunities is the right to pass through, reside, trade, and pursue a common calling. Own property, protect from higher taxes, sue or be sued. Commercial hunting or fishing when it's not a corporation. Not included are recreational hunting and fishing and state college tuition. Exceptions. Is something a protected privilege and immunity? Let me say that list again. Is something a protected privilege and immunity, which is the right to pass through, to reside, to work, to own property, to protect from higher taxes, to sue or be sued, or to commercially fish or hunt. Then, can this restriction be justified as the discrimination being another kind of evil? And the restriction protects against this. So this is, it's different because it's different. Taxing power. I'm gonna need a hypo to add to this one. Congress can tax for any revenue purpose. It can always tax under Commerce power, can always tax to get revenue. Tax can be for mixed revenue or regulatory purposes, regulatory behavior. All taxes have a regulatory function. Court is not looking for motive. Congress can tax to achieve any end for another enumerated power. Power to tax is an enumerated power all by itself. Only limits to taxing power are what is imposed by other enumerated powers. If there is no revenue generating purpose, but is strictly regulatory, it is still within taxing power if it reads like a tax. It looks like a tax, even if it only regulates. It does not have a revenue purpose and doesn't read, if it does not have a revenue purpose and it doesn't read like a tax, it may be invalid, seen as a penalty, not a tax. There's an objective test. If Congress has an objective reason for the tax, Congress will allow it. The courts will allow it, not Congress. Congress will because they made it. When challenged, the plaintiff has an uphill battle to prove why there isn't a reason. Labeling it a penalty or a tax does not control whether it is a tax. It should vary by income, be collected by the IRS, generate income. Examples, $200 tax on guns, but only sell for $50. Yes, it generates some revenue. Motive is irrelevant. It looks like a tax, and it charged by the amount of guns sold. Child Labor Act, no. The tax was too high. It looked like a penalty. Regulation and not revenue was purpose. Wasn't applied to the number of children, just a blanket penalty for any child. It was collected by the Department of Commerce, and it was required mens rea, which means they had to have intent, and taxes don't have that. All right, spending power. We are almost done, guys. Spending to power. Spending power is a separate enumerated power. Congress can spend money for the general welfare. Madison says no, spending must be related to enumerated power. Hamilton says yes, it is a standalone enumerated power. Court has adopted this today. Congress can impose conditions on federal funds as long as Congress believes it's for the general welfare, the court will allow, unless it's clearly wrong, arbitrary, not rational. Coercions, however, is contrary to spending power. Congress can give money to states to encourage things they cannot demand, like money for public schools that do not allow guns. Spending is for the general welfare, or what Congress believes is the general welfare, not to legislate the general welfare. Challenging spending. Rule. Taxpayers do not have the power to challenge Congress's spending power. Exception. If tax and spending are together in an integrated program, then the tax and spending may be challenged. The court does not have to prove a tie to the federal interest or impact. Sabari case, government agencies receiving over $10K of federal funds were not allowed to take bribes. Couldn't prove the bribe had any federal impact. Didn't matter. The money given by the Fed didn't have to relate to the bribe. The spending of the feds just made the bribe illegal. So if they're using the penalty as a whip, it's not allowed. Conditions on federal spending. Spending must be within general welfare. When Congress gives money to local people, Congress gives conditions, and they may. Congress sees it as fulfilling the necessary and proper clause. And it must be rationally believed that it's for the general welfare. Conditions must be unambiguous and on the face of the grant. Conditions must be related to the purpose of the grant and the expenditure. The purpose and conditions cannot violate the Constitution. Congress could not give a state money for health care for a certain racial group because it would violate civil rights. Conditions cannot be onerous as to the coercion to produce compulsion against instead of encouragement. Examples, the drinking age. Money was given to states for federal highways. Congress said if the drinking age was under 21, they would cut the funding. The drinking age was 1, for the general welfare, 2, necessary and proper because drinking leads to highway accidents, 3, for the purpose of making highways safer, 4, not violating other rights, does touch the 21st Amendment, but does not violate because it doesn't force the state, 5, used to encourage, not coerce, as the total it would affect is 0.5 to 1% of the state budgets. But Medicare does not hold up because it's not, although it is for the general welfare, necessary and proper to make everyone healthier, it doesn't violate any rights, but pulling the funding because of Medicaid would have taken 10 to 40% of the state's budget. Rules not encouraged, that's a compulsion. War power and effects of. Inflation is an effect of war. Freedmen Act was an effect of war. Can and has been used as an excuse to deprive people of human rights. Treaties and executive agreements. Treaties and executive agreements. These are controlling law but can be overturned by Congress. In law, last in time controls. Supremacy clause alludes to executive agreements not being subject to constitutional control. This is not true. Reed v. Covert, the clause was framed to allow for executive agreements from the Articles of the Confederation period before the Constitution was written. Of course, treaties and executive agreements are bound by the Constitution. Property power. Taxpayers do not have the standing to sue over property. If Congress controls property, they can also control what is on it, wild animals. Money. Congress can coin money. They can regulate the value of money. They did away with letting creditors demand payment in gold to protect themselves against inflation. Naturalization. Congress can pass uniform rules for naturalization. States cannot. People outside the country do not have the constitutional right, and Congress has complete control over this. Maritime admiralty. Federal courts have jurisdiction over maritime and admiralty. That gives Congress the power to regulate copyrights, patents, and trademarks. Give Congress power to protect for a term. Congress decides the term to reward ingenuity and deter prosperity. Intergovernmental immunities under the enumerated power to create banks and raise an army. Only seen when federal regulates state or state regulates feds. I don't know I had that in there. Intergovernmental immunities. Only seen when Fed regulates state or state regulates Fed. The hypo is state speed limits. They do control how fast federal postal trucks can go. So the intergovernmental immunities arises from a misuse of the Supremacy Clause. Significant regulation is not allowed on what feds can limit. Congress can regulate state and local government just as they can private entities. Only limitation is they cannot commandeer state and local government to force federal compliance. They cannot force the state to be their bouncer. Radioactive waste case trying to force the state to force private enterprise by penalties to the state. Used to be a separate traditional cannot enforce, non-traditional can enforce. This can be struck down. If a government owns a concrete factory, it's non-traditional and like a private business. If a rule applies to a congressional page, no, that's traditional governmental rule. it was struck down because Congress was viewed as an extension of the state, and therefore the state didn't need to be protected from Congress. I'm going to need to do a little work on this.